It's Monday, and that means it's time for another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about post-offence conduct. Cases that should have gone to the Supreme Court of Canada, but didn't. Jason Maestrello was convicted of a number of offenses arising out of a drug rip that went bad. Ultimately, there were a lot of questions at trial about whether or not Mr. Maestrello was the perpetrator of the drug rip and consequently the murderer, or whether or not somebody else was the person who was responsible for this. One of the things that the Crown tried to allege was that Mr. Maestrello's after-the-fact conduct, including disposing of a number of items related to the drug rip, demonstrated his guilt. This is known as post-offence conduct, or consciousness of guilt evidence. Mr. Maestrello argued that the trial judge was obligated to warn the jury about the use to which they would put that evidence, and give a limiting instruction to keep the jury from using it against him if it also supported the theory that another individual had been responsible, a third party that had been involved had been responsible for the murders. The judge failed to give that limiting instruction, and the Court of Appeal found that that was an error, and the trial judge was required to give the instruction. The Crown appealed the Court of Appeal's judgment, arguing that it represented an impermissible expansion of the law about post-offence conduct that effectively required the trial judge, in any case where the Crown was relying on post-offence conduct, to give an instruction that would say, if somebody else could have engaged in these activities, then somebody else could have been the murderer, thereby raising reasonable doubt in every case. This, of course, is an expansion of the types of jury instructions that are typically given in these cases, and it's not typically seen that a jury instruction like this would be given. And so whether this is something that should be given in every case, and whether it's something that should be given only in specific factual circumstances, remains to be seen. The impact of this Court of Appeal decision remains to be seen, and the Supreme Court of Canada really had an opportunity here to clarify the use of this new limiting jury instruction, the circumstances in which it should arise, and the circumstances in which it would be more prejudicial to the Crown's case and to the administration of justice to give that type of instruction, where it could confuse juries or cause them to think that the Crown hadn't proven their case, or that necessarily they were required to rule in a particular way. The Supreme Court of Canada could have reined in this instruction to make it one that was sensible and applicable in a way that would satisfy the Crown with their concerns about it, but also protect against the threat of wrongful conviction and guard the presumption of innocence in an appropriate way in a trial. Unfortunately, the Supreme Court of Canada failed to recognize the novel issue that was raised by this case and the potential that this novel issue has for significant expansion across the country. This was an opportunity that was missed, and unfortunately it's going to take another case like this for the Supreme Court of Canada to have the opportunity to chime in. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.